You see, one of the requirements is notification of the charges shall be sent to the student's parents or guardians by certified mail. Do you see that?
Yes.
So there must be written charges, and they must go to the parents, correct?
This is in a public school, correct?
Yes.
Yes.
And at Westtown School, there is no requirement of written charges and no requirement of notification of the parents in writing, correct?
Correct.
And subsection 2, there must be in a public school at least 3 days' notice of the time and place of the hearing. A copy of the expulsion policy, notice that legal counsel may represent the student and hearing procedures shall be included with the hearing notice, and a student may request a rescheduling of the hearing when the student demonstrates good cause for an extension. You see that?
I do see that.
There must be at least 3 days of time before the hearing, correct?
Yes. This is a public
Westtown School does not permit students up to 3 days of time before the discipline council hearing, correct?
We'll stipulate to it. That's correct.
Not necessarily. Yes, that's correct.
All right. And the copy of the expulsion policy is not provided to students by right at Westtown School, correct?
A copy of the expulsion policy.
Objective form. Go ahead.
Students have our handbook. I'm not sure what you're referring to.
A specific reference by the school under what provisions of the Westtown School handbook the student is going to be expelled. There's no such policy provided to the student, correct?
They have the handbook.
But they have no written statement. They have nothing else given to them in writing that provides what they're about to be expelled for or charged with, correct?
They have meetings with the administration, with their advisor, but not necessarily a written document. That's correct.
Okay. Subsection 12.8b3 states that the hearing shall be held in private unless the student or parent requests a public hearing. In the case of Westtown School, there is no option for a public hearing, correct?
That's correct.
Subsection B4, student may be represented by counsel and may have a parent or guardian attend the hearing. Do you see that?
I do.
And at Westtown School, the student may not be represented by counsel, correct?
That's correct.
And at Westtown School, the parent or guardian, even though the student is a juvenile, a child, parents are not permitted to attend the hearing, correct?
That's correct.
And subsection B5, student has a right to be presented with the names of witnesses against the student and copies of the statements and affidavits of those witnesses. You see that?
Yes, I do.
And at Westtown School, your students are not given the right to be presented with the names of the witnesses against them, are they?
No, they're not.
And the students at Westtown School do not have a right to receive copies of any statements that have been made against them, do they?
No.
Subsection 6 of the public school rules. The student has a right to request the witnesses appear in person and answer questions or be cross-examined. You see that?
I do.
At Westtown School, the accused student does not have a right to have witnesses appear, do they?
That's right. That's not part of our discipline process.
And they do not, at Westtown School, have a right to cross-examine, to question other students, correct?
They do participate in a hearing with the discipline council. They can ask questions in that meeting.
But they do not have a right to call and ask questions of other students, do they?
During the discipline process.
Correct.
That's correct.
Subsection 7. In a public school, the student has the right to testify and present witnesses on his own behalf. At Westtown School, the students do not have a right to present witnesses on their own behalf, do they?
They don't have the right to present witnesses. They do have the right to bring their advisor and prefect.
And subsection 8, in a public school, there shall be a written or audio record of the disciplinary hearing kept. There is no right at Westtown School for there to be a written or audio record of the discipline council hearing, correct?
That's correct.
So in fact, you don't have any verbatim transcript of what happens inside a disciplinary council, correct?
That's correct.
Based on what you see in Baird Exhibit 4, is it your understanding that Westtown School students have fewer rights than public school students do, facing an expulsion?
Yes, as described in this document for public schools.
the decision as to whether or not a student has violated a major school rule could lead to dismissal. So it's an important decision both for the student and the dean, correct?
Objection to form. You may answer.
Yes. And the questioning of the student, you said yourself, the statement of the student is often the most important part of the case, correct?
Objection to form. You may answer.
I'd say it depends on the circumstances, but often that is, yes, that's a very important part of it.
Now, prior to you deciding to interrogate them, you and Chris came up with a plan for how you were going to do it, correct?
Correct.
And you and Mr. Benbow decided first that you would isolate the girls, correct?
Correct.
And that you would try to separate them from each other, correct?
Correct.
That they would have no contact with their parents until you were done with the substantive interviews, correct?
Correct.
So you waited until the girls were coming out of classes and then went down, put them in separate rooms, isolated them, and interviewed them all separately, correct?
Correct.
And that interrogation lasted 4 to 5 hours, correct?
Correct.
All right. And during that time, let's just focus on her. She was crying, correct?
During the process of my questions, yes, she was.
Okay. She was emotional.
She was.
She was the right to have anybody in particular present when they are being interrogated by the dean or the representative of the dean's office.
Objection to the form. You may answer.
Again, I'm not wild about the term interrogation, given some of its connotations, but when it is possible for us to do so, we strive to have the student's advisor present, given schedules and not wanting to keep a student sort of out of circulation from classes and other things longer than necessary. There are times when there would not be someone else present. So I'm not sure if you'd said right again.
I did say right.
I think you did. I'm not sure we would say that there was a right to having someone else present, no.
So a student may be questioned alone by the dean or the representative of the dean's office prior to the dean making the decision they violated a major school rule.
Yes.
Do you have training in taking statements?
No,
Do you have training in interrogation?
I do not.
Do you have training in recognizing a false confession?
I do not.
And do you have any training in the things that lead up to a false confession? Promises, deception, isolation. Do you have training in any of that?
I do not.
Nothing further. So looking back at the various points, you acted as an investigator in the case, correct?
Yes.
You act as the equivalent of a prosecutor in the case, presenting the case to the discipline council, correct?
Object to the form of the question. Go ahead.
Yes.
You act as the equivalent of the jury in the case, deciding if the student is actually guilty of the offense as part of the dean's office, correct?
Object to the form of the question. Go ahead.
Correct.
You act as the equivalent of the judge in the case, sitting on the discipline council and deciding the punishment for the student, correct?
Object to the form of the question. Go ahead.
Yes.
And do you believe that acting in all those different roles, from investigator to prosecutor to judge and to jury, that presents any conflict of interest for you?
No.
Okay. And you destroyed the notes that would have included his initial denial if you wrote them down, correct?
Object to form. Go ahead.
Yes.